And when it comes to the transcripts, when it comes to the other information, anybody that wants any of that information regarding my cases, you're more than welcome to have it. In fact, I need to probably do something to stick that inside the Dropbox as well, and just put State Farm files inside the Dropbox. So somebody send me a text message and say, Greg, update the Dropbox to include a folder that would chronicle to some degree, at least through the information and exhibits, what's going on in the State Farm case. But as I was saying in the beginning, I'm preparing for my case on Monday, my hearing on Monday, where they filed motions to dismiss my case, and they're probably watching. If they're not watching now, they'll be watching later. But who gives a damn? The They don't address the underlying action, and one of the reasons that I'm moving to disqualify this particular judge, Paul Huey, who's actually a witness in my federal case, and also he's a witness to what happened in the prior case. I'm hoping that he does what is the honorable thing and just dismisses himself. He knows he can't be unbiased. But one of the things that he said in one of his hearings, and I'm gonna pull this up for everybody to see, which is what not just baffled me, kind of irritated me. We take down a couple of these things, is when he was saying that he told me that I teach contract law. That's what he told me. I teach contract law. And what was another thing that's kind of interesting and was pointed out by one of the gentlemen that you spoke to earlier is like he became part of the litigation process because he began to argue for the other side as to what I supposedly done. And for those who don't know, in that case, the attorneys for Miss Tucker, who I sued because of the negligence of Chandra Tucker, and by the way, they filed what's called a notice of negligent admission in the case. But at any rate, the attorneys failed to provide, and as you see, this is the case that we're talking about. But the attorneys failed to provide to the court and to myself what we call a certificate of attendance and authorities. And if anybody's ever done, anything regarding mediations in Florida, you know that anybody who is going to attend a mediation, they're required by rule, and I'm going to just pull it up for you all, a certificate of attendance and authority, and it has to be done supposedly 10 days before the mediation. That did not happen in my case. Not at all. And as we've discussed here already, the rules are the rules. And the rules, although they can be to a degree, you can stipulate to things, as I believe that's what what Brett was saying, is you can stipulate to something, but the court can't rewrite the stipulation. The court can't rewrite some agreement. That's impermissible, particularly when the language in the agreement is what they call unambiguous. And let me push this up here and make sure I'm looking at the right page for you all.
Hey, Greg, I got something to say on that real quick.
Yes, sir.
I had an epiphany recently, and this helps me kind of categorize where I am. The statute, let's say it's just, you're talking about child support, right?
Mm-hmm.
They're restricted to calculate child support, restricted by that statute. So if you walk into the courtroom and you and your ex, you've made no stipulations whatsoever, and you say, all right, fine, just based on the statute, the court gets to calculate child support, they can apply all of that statute. If you and your ex stipulate to certain things within that agreement that that somehow impact child support, let's say like if you're paying alimony, that would impact the amount of child support paid.